start here this morning. The 5 men accused of killing Senzo Meyiwa are expected to plead again as the trial starts afresh. They will also get the opportunity to apply for bail again. Judge Ratha Mokgoatlheng came, of course, out of retirement to take on this case. And senior reporter Silindelo Masikane is monitoring proceedings in Pretoria and joins us now for those updates. A very warm good morning to you, Slee. I mean, another day, another court sitting in the Senzo Meyiwa murder trial. The big question is, what is to be expected from today?
Certainly so. We saw the trial officially beginning anew yesterday with, of course, a new judge in tow, that is Judge Ratha Mokgoatlheng, who, of course, didn't waste any time in making his presence felt in this courtroom, showing counsel as well as those who are watching this case quite closely that it doesn't seem as though he's going to entertain any more delays, ensuring that counsel for the state and the defense held a pre-trial conference in the afternoon yesterday, and also ensured that legal aid officials came to court in order to give counsel for the defense application forms for legal aid to begin to cover the costs of the accused legal fees. Now, of course, we are anticipating today that there is a possibility, of course, a strong possibility that the first witness in this new trial will be called, and we are expecting the accused to put their pleas on record. But to unpack what we can expect, I am joined by legal expert Mr. Marius du Toit. Thank you so much for your time this morning, sir. Let's just start with what we saw yesterday with Judge Ratha Mokgoatlheng, really, I think, trying to stamp his authority in this courtroom and making a number of orders in order to ensure that we begin with a witness this morning. Perhaps maybe unpack that for me in terms of the expectations of this new judge to conduct a speedy but also a fair trial.
Yeah, Slee, I think when any judge takes over a matter like this, especially a matter that was partly heard before, you can only expect and hope that this judge will stamp his authority quite quickly in the trial and try and put measures in place to ensure that the trial not only starts but continues. And I think that's exactly what we saw yesterday. So that was a breath of fresh air compared to judgments being delayed previously on bail applications and the matter being staccato, stop-start all the time. So we can only hope, Slee, that this judge is taking control of the proceedings, and I think it's pleasing to see that he's stamping his authority. It's pleasing to see that he's put measures in place to ensure that the matter will start and run. And I think that's what one would generally expect of a judge, to take control of the proceedings, because he's ultimately the person in charge. He's ultimately the person that would dictate the pace and would dictate the way the trial is going to take place. So I think it's a big positive in the right direction.
Let's talk a little bit about the state's case, Mr. du Toit. I mean, we saw in the initial trial that was nullified that the state began with forensic evidence, but now it does seem as though they may have to begin with a witness who was in the house on the night the murder took place. Talk to me about how this hurts or perhaps helps the state's case in terms of their strategy in how they're going to present evidence now moving forward.
Slee, so first and foremost, when you run a trial as a prosecutor, you would want to start well and you'd want to end well, keeping in mind that there's a lot of evidence that would be introduced during the course of the proceedings, which might just be matter of fact, which might just be chain evidence, or it might just close certain evidentiary loopholes that might exist, and they might not be so fantastic. But you'd want to start well and you'd want to end well so that it leaves a good impression with the judge. That being said, we've already run a trial here halfway through. And now the state, I think, is in a disadvantage in the sense that the element of surprise to an extent has been lost. Now they have to run the trial afresh with the same witnesses. And I think in this instance, it might be as simple as just calling a witness that's available, because all your witnesses might not necessarily be available on the first day. Some of them might only be available on the second day. Now, from what I recall, Slee, and you'd be better to remind me of that, but I do not recall that this was such a fantastic witness the last time round. Now, having said that, Obviously, the witness can't deviate from what she said previously because then her credibility would be attacked. So one can only hope that, maybe this is the way the state wants to start strong. And let's hope that that's what they will achieve with this. But somehow, I think the whole atmosphere was lost in the first trial, the atmosphere, the element of surprise. So I think in this instance, it's maybe just a question of calling witnesses that are available just to ensure that the matter is running and not stop-starting all the time.
Lastly then, I mean, just how much can the record of the nullified trial be used in this new trial?
Okay, so in terms of Section 235 of the Criminal Procedure Act, you can have any transcript of proceedings admitted to a later proceedings, provided there's a transcriber certificate to say that this is a true reflection of it, and provided the parties agree to it. So let's assume, for argument's sake, there are 3 or 4 witnesses that have testified, everybody is happy, they don't want to adduce anything else, then they can, in principle, agree that that portion of the record just be handed in and that the judge has sight of the transcript of that proceeding. That being said, I'm not 100% sure that we have the same legal team for everybody. Yeah, we know that Tefu is not involved, Advocate Tefu that was previously involved. So for that reason, you might say that these advocates might say, well, listen, we want a second bite at the cherry. We want to cross-examine this witness afresh, and we're not going to consent to just having a portion of the record admitted. And for that reason, the state would have to call those witnesses again. So can evidence be adduced by way of just admitting portions of it? Absolutely. And I think that was the goal yesterday with the pre-trial that the judge ordered the parties be held yesterday before the close of proceedings, so that they can find common ground and agree and say, this aspect we admit to it now, this aspect remains an issue in dispute, this aspect needs to be proven by the state, so that you are able somehow to try and circumvent the delay of unnecessary evidence. And I think that was the intention yesterday with the judge taking control. So we can only hope that unnecessary evidence would not be adduced. But having said that, if the parties do not agree to it, well, there's nothing you can do. Then those witnesses, unfortunately, would have to testify again. And keeping in mind, they can then be cross-examined with the previous statements they made at the previous trial.
Lastly then, Mr. Du Toit, just quickly, how far do you think we can get with this trial, given the fact that we are sitting until at least around the 15th of September?
So, Slee, I mean, if we are able to run continuously without delays, you remind yourself, Slee, that there were a number of unfortunate delays in the last trial. There were peripheral issues that ought not to have been issues in the trial. We had Advocate Tefu's mandate and to what extent he was entitled to be involved in the trial, if not. So you had all those peripheral issues which basically sidetracked the trial. In this instance, we have a judge that's now taken control. He wants the trial to start. The state, I would assume, have all their witnesses ready to proceed. So I think we'd be able to get quite far. Keeping in mind that it's impossible to gauge how much cross-examination is going to take place of a certain witness. I, as the prosecutor, might think this witness is going to be an hour in the witness box, and then he's 3 days in the witness box, and suddenly, the witnesses that I planned for the week are now too many. Now they have to be rolled over for the next week. And although the High Court has a continuous role, which means that the matter continues one day after the other, ultimately, there's a period that's been allocated that you've alluded to now. And if that period is finished, well, then they have to allocate a new date. So we can only hope, Slee, that much of the evidence would be adduced by then. We can only hope that that's enough time. I think this matter is receiving the attention that it deserves at this stage. And I can only hope, and I think that's maybe the plea of the public at large as well, is that this matter would maybe get to some finality within this period. But chances are it might be postponed if we're not able to get to everything.
Thank you so much for your time this morning. That is legal expert Mr. Marius Dutoy unpacking what we can expect in terms of how this trial is going to unfold, and of course the expectations from the state, the defense, as well as the judge in how he is going to conduct a speedy but of course also a fair trial. We are expecting court proceedings to start at around 10 a.m. this morning, and of course we will be bringing you those visuals live as soon as court proceedings begin. It's back to you in studio.
Thank you so much, colleague. Indeed, the time factor being of essence to also Senzo Meyiwa's family. We know how much they've been reeling to have this case coming to an end and finding justice for Senzo Meyiwa. But we'll be sure, Slee, to catch up with you once again as soon as those court proceedings do commence out in court.